Courtroom panel. I'm honored this morning again to be seated with Judge Patrick Higginbotham and Judge Corey Wilson. We have all 3 states in the circuit covered, so we've read your briefs and look forward to your arguments. We have a full plate today, so we'll press forward. The first case we have is number 20-20387, Prim versus Stein et al. Mr. Kallinen.
May it please the court, I am Randall Kallinen for the appellant, the Prims, a married couple. Almost 30 years ago, the United States Congress passed the Americans with Disabilities Act. Why? The stated purpose is so that people with disabilities can enjoy life just as any other person can. Mrs. Prim, a law-abiding citizen, never arrested before in her life, almost 60 years of age, highly educated individual, living in the Woodlands, Texas, pretty close to the Cynthia Woods Mitchell Pavilion, where they have concerts. And these are concerts which a lot of them are popular among people her age because these are bands from the 80s, 90s, 70s, 50s, 40s. So she went there to enjoy herself. And first she had some drinks with her husband and a dinner at a local restaurant. If you're ever there in the Woodlands, they have a nice downtown there. And they got all these activities. It's north of Houston. I'm sure you all have heard of it. It's growing faster than a weed, just like Montgomery County is growing faster than a weed. They have 700,000 people in Montgomery County. So this is not a podunk town. As a matter of fact, they have their own lawyer who will come to the Fifth Circuit Court of Appeals on their budget to come and argue. They don't even have to.
All right, let's stay in your argument.
Okay. All right, Your Honor. And Mrs. Prim just wanted to enjoy herself, as the ADA stated she could enjoy herself. She has multiple sclerosis, and that causes her to, stumble a little bit maybe, and she's legally blind. But is she supposed to stay home now? Is that what she's supposed to do? We've asked for injunctive relief in this case because the testimony by both Montgomery County and the Cynthia Woods Mitchell Pavilion and its employees is ADA training. What's that? We've heard of wheelchair ramps before and wheelchairs. Yeah, we got that down.
All right, let's cut to the chase. What's your strongest argument on your ADA claim?
Well, there was no. She suffered from MS, and the symptoms that she had was what caused her arrest. Even though that she told them, both the plaintiffs said, "Hey, look, she suffers from MS. I suffer from MS."
Is it disputed that at the dinner, they had bottles of wine or whatever? Is there a dispute over the alcohol consumption and so forth and all of that?
Well, they did have some alcohol, but anybody can have alcohol, and what we're saying is that her symptoms were not the result of alcohol. She has those symptoms anyway, and it's a fact issue.
Well, we get that part, but also in the briefs is the notion that, they had a nice dinner, they had some wine, this precedes shortly going to the show, I had some alcohol there, etc. So we sort of had this convergence of the consumption of alcohol and her medical conditions. So we're trying to get all of that. I hear your argument. You're arguing, the MS, but I'm trying to get in my head, is there a dispute over that they had some alcohol at dinner, closely followed by alcohol at the theater, etc., and it's after that. So if she's hitting the wall and so on and so forth, is it because she's inebriated? Is it because of that? It's definitely a fact issue. I'm just trying to find out where you are on the alcohol part.
I am in the same place that Lance Platt is, a PhD who studies these issues. And according to his testimony, and he looked at all the different times and the amounts that were admitted and in the evidence, and he said that under these conditions and because of the length of time, his opinion was that they were not intoxicated such that they would meet the standard for public intoxication.
The question is how they presented. They had been consuming some alcohol, but then what they're manifesting is to an officer, a reasonable officer, is that there's some disability from consuming alcohol. In other words, it's unfortunate that her underlying illness manifests itself in ways that might be interpreted as being a person inebriated.
Well,
How do you deal with that?
well, there's two issues there. One is whether there was reasonable cause, probable cause for the arrest. The second one is should some consideration for the ADA have been made. And those are two separate issues. Now, under the case of Bruce versus Ellis out of the Northern District of Texas, 2013 Westlaw 1091241, they go into these issues, and there they determine that.
Is that in your brief?
What's that?
That case in your brief?
I'm not 100% sure. It's in this particular. I think it is, but it certainly is.
The point is, it ought to be in your brief. Otherwise, you shouldn't be arguing it to us unless the ink is still wet on it. That it came out yesterday. But press on.
Yes, Your Honors, and in there, even people who have drank alcohol, they still have to exhibit the signs that they're a danger to themselves or others. Remember, this is not like DWI. This is public intoxication, where you have to be a danger to yourself or others due to your intoxication.
But they were exhibiting those symptoms or those signs, correct?
Ms. Prim was, Mr. Prim was not, and he testified extensively, which is in the documents, that Mr. Prim was not exhibiting those signs.
I thought he was bloodshot eyes. I thought he was having trouble slurring his words. I thought he was having trouble standing up without the help of a wall also.
Those are the accusations of the opposing side, which were disputed in the deposition testimony and throughout the facts here. As a matter of fact, we had video testimony, video evidence, and in that video evidence, you see Mr. Prim walking with handcuffs being pushed, walking like this. I'll just do this demonstration here. I know it's not words, but he's walking just fine. And if you look at his eyes, I don't see bloodshot eyes in there, and it's up to a jury to determine, unless it's absolutely obvious what's on the video.
Well, but with regard to the officers, as I want to unpack a couple things if I could, with regard to the officers, isn't the question whether they reasonably perceived that they were publicly intoxicated? And if so, wouldn't they be protected by qualified immunity?
If so, Your Honor, but we don't get to the if so because the testimony is there's no bloodshot eyes, no slurring, we have videos. This is clearly a fact issue. And furthermore, there's evidence that whatever interaction was with Harshaw, who is an employee of the Cynthia Woods Mitchell Pavilion, who first contacted him, there's evidence that he was angry and maybe he was taking, I'm going to take...
What should the officers have done?
What's that?
What should the officers have done?
Well, I would like to point out to you the words out of one of the officers' mouth.
What's your understanding of what?
Well, Your Honor,
In your view, what?
they could have let them call their son, who's a lawyer, who could have come and picked them up. They could have called them a cab. They could have called them an Uber. Their friends were still there, according to their testimony. They could have said, "Hey, let me go back to the seats and let's contact them."
I thought they didn't have their cell phone.
Yeah, but they could still walk back to the seats. They were still in the Cynthia Woods Mitchell Pavilion.
Where was the cell phone?
What's that?
Where was the cell phone?
I'm not 100% sure, Your Honor.
Was it on her or his person at this time when you say they could have let him call the son?
No.
So where was the phone?
In their car at home? I'm not sure. I mean, not in their car because they walked, because they're within walking.
They didn't take the cell phone to the concert with them. Is that it?
That's correct, Your Honor.
So if they could have let him call the son, it would have been by virtue of somebody else's phone not there.
Sure, and there were a ton of people and a bunch of officers and employees of the Cynthia Woods Mitchell Pavilion there. Furthermore, they could have driven them themselves because once again they were going to walk a short distance to their home in the Woodlands as they had done on many, many occasions.
Like they had to cross two busy parkways to do that.
Yeah, well, there's always intersections and so forth, but they've crossed them before, and there are lighted,
Crossed them before, presumably in a different state than they presented themselves in. One of the officers' responsibilities is also not just to arrest people, but to detain them, to protect them from themselves. And and officers will do that, I assume.
Well, Your Honor,
But look at it this way. Could a reasonable observer, an officer here, conclude that given their difficulties, that they would be unsafe in their assertions that they want to walk home and the distance across the golf course and through two busy intersections, that it would be unsafe for them to do that? If the officer had failed to do that, then you would be talking about the failure of the officers. What should the officer have done to that?
Giving them a ride home, give them the phone, let them call Uber, let them
He
call.
didn't have the phone.
There are cell phones everywhere, Your Honor. Everybody here has a cell phone, and it's probably.
I thought these individuals, I thought they did not have their phone with them.
These two individuals did not have a cell phone on them. However, all the individuals at the security.
Having a phone is not going to solve the problem.
Well, the phone is one issue. However, they lived a short distance. Any one of these individuals could have given them a ride. But why was their arrest? Another thing is they could have said, well, why don't you just sit here for a while and let us observe you? But no, they did not. What they decided was, the only thing to do for this person who suffers from MS and blindness is to arrest him and take to the Montgomery County Jail, which I have cases against the Montgomery County Jail, and I'm not testifying. However, there have been, deaths due to medical care and other reasons at the Montgomery County Jail. And once again, I'd like to point out that this is not a small county. It's one of the fastest growing counties.
Stay with the facts here. You're going to run out of time giving us all that other information. I mean, you got a number of issues, and I don't want you to run out of time before you hit them all. So.
Yeah, yes, Your Honor. The videos, I think, are very telling, both in the squad car and at the Cynthia Woods, which were almost immediately after the arrest, within just minutes. And you see these individuals, Eric Prim, not displaying signs of intoxication. He's not slurring his words as the officers are saying, which, by the way, is one of the reasons given in the cases. If there's testimony or that contradicts the officer, then, of course, you're going to have another debate, fact issue, for the jury.
Counsel, I want to go back to what Judge Stewart asked from the get-go. You started out with a reference to the ADA, and he asked you which specific provision or which part of the ADA were you proceeding under, and I wasn't clear on your answer on that. Tell me what provision of the ADA you contend that any of the defendants violated.
Well, they provided no reasonable accommodation, Your Honor.
Didn't they get her a wheelchair?
The wheelchair, she was forced into a wheelchair.
Well, wait a minute. Didn't they get her a wheelchair?
Give is the wrong term. They forced her.
Didn't they get her a wheelchair?
They put her in a wheelchair, Your Honor.
Well, we don't know who put her in the wheelchair. In
That's
other
what she
words,
testified to.
the allegation is that somebody forced her into the wheelchair, but I didn't think we knew if that were the defendants who did that.
Yes, Mr. Harshaw.
Mr. Harshaw did it.
Yes, and that's what she testified to.
All right, so what else did they fail to do? I mean, a wheelchair would certainly be an accommodation for somebody who couldn't walk, correct?
Well, an accommodation to the security office where they were arrested, where the
What else do you say they should have done under the ADA that they did not do?
allow them to give them a ride home, let them call somebody.
So the ADA requires a concert venue to give anybody who needs a ride home a ride home?
Not
Where in the law is
anybody.
that?
This is about disabilities, Your Honor.
Where in the law is that, though?
That is a reasonable accommodation. And furthermore, when you're considering the ADA, you do not have to, there's no qualified immunity applicable to the ADA. So the court can decide that those were reasonable accommodations. Also, the other ones I mentioned, whereby calling any of their acquaintances, Uber, letting them call Uber, calling Uber for them, calling a cab. They had money. Why didn't you just call a cab? The Woodlands is a.
They didn't have a phone. They could not give them a phone number of any person to contact. Correct?
That is correct, Your Honor. However, their son is a lawyer, and just simply by Googling his name, you get the number where he can be reached, because he's a young lawyer who can be reached at any time. If they would have just Googled his name,
How do the officer know that?
because they were, well, how do they know that you can't find someone's number by Googling? I think that's kind of not it's not uncommon. especially in this.
Well,
to
out of
get
all
that.
out of all that you said everybody in here has a phone. Who goes to the concert, navigating the way they have to go with what you say they had, and leave the cell phone at home? You don't have to answer that question. But I'm like, who does that? If everybody in here has a phone, I mean, who goes to it? I'm not blaming the victim, but I'm just saying, you're saying all this the officers could have done about calling, but they go to the concert, they've got dinner, they've got all these issues, son's a lawyer, no way to communicate, and don't have a phone. Yet you want to say the officers could have Googled this and so forth, but you haven't answered Judge Wilson's question of where in the law or any, which I start off asking you, what's your best case? What's your strongest argument? You're explaining no accommodation. So as your light rounds up, tell me your best ADA case that helps and supports the argument that you're making. You got a red light, but you got time to answer that question. What is the best case? You ought to know. You're looking through the brief. You ought to know what your best case is at the podium.
Yes, Your Honor. I think probably one of the best cases would be Lightburn versus County of El Paso, mentioned on page 57.
And it holds what?
Well, it holds that in order to entitle a plaintiff to relief, you got to show that they are excluded from participation in or being denied benefits or services, programs, or activities for which the public entity is responsible. In this case, this would be arrest and public safety. It's been long determined that the ADA applies to the police during arrest scenarios. And of course, both the center and the center itself is up.
Okay, that's all right. I asked you what the best case, you're giving me an argument. Okay, my last case is, what is the relief you want from this panel?
We would like the panel to overturn all of the issues that are brought forth in the brief, and Ms. Prim's major goal is this injunctive relief that could be afforded against both Montgomery County and against the pavilion or venue defendants, which is the Cynthia Woods Mitchell Pavilion.
Okay. All right, you've saved your rebuttal time. Thank you for your answers. We'll hear you when you come back up. Thank you, sir. All right, for Mr. Harshaw, Ms. Yoshor, is that correct? Okay.
Thank you, Your
I
Honor.
don't want to butcher your name. I apologize if I didn't get it
You
right.
did it exactly right, Your Honor, and I must say it's good to be back in a courtroom after so many months. May it please the court, I'm here today on behalf of the pavilion defendants. So they're the three: John Harshaw, who's a high school PE teacher by day and a coach who works security at night for the pavilion; the Cynthia Woods Mitchell Pavilion, or the Center for Performing Arts, the Woodlands, where the events occurred that are at the heart of this case; and Live Nation Worldwide, Inc., the entity that books and manages the events at the pavilion. We've called these defendants the pavilion defendants in our briefs. They call them the venue defendants. I want to just make clear that I do not represent Montgomery County or the individual officers in this, although they've been sued, and we believe that summary judgment was properly granted in their favor too. The gist of the activity alleged against my clients really is this: that the pavilion defendants, we're giving the Prims every benefit of the doubt in our motion for summary judgment, which is exactly what the judge did below as well, that Mr. Harshaw escorted the Prims to the first aid office towards the end of a concert because they were stumbling and looking like they were having trouble making their way to the exit. He had watched them for a little while. He saw they couldn't do it on their own. He called for a wheelchair. That wheelchair came. Whatever MS symptoms Mrs. Prim was having that evening certainly do not affect Mr. Prim, who has not alleged ever any sort of disability. So what happened on June 18th, 2017 should never have been turned into a federal case. The district court patiently considered all the evidence here, all the cases presented. By the way, the Bruce case was not presented in either of the briefs, the opening or the reply brief, and finally dismissed this case after 2 years, and the district court got it right. Now,
Counsel, let me ask you this question in your version of facts. Counsel opposite said that there's no evidence that Mr. Prim was having trouble moving around or had bloodshot eyes, things like that. Or he said, to the extent the officers say that, there's a fact issue, so respond to that. I mean, is his read of the record right or not?
Well, Your Honor, there is evidence in the record from Deputy Stein, who said that Mr. Prim was swaying. His eyes were closed. He was not able to answer questions. It's undisputed that he refused to give information about his address, his phone number, his son's phone number. The record is replete with evidence from each of the officers that instead of answering any questions, he simply insisted that he had the right to go home and that he was going to be.
So what about counsel's argument that, well, Mr. Prim says something different, so that's a fact issue, summary judgment not appropriate? Is that the right read or no? Help me with that.
Well, Your Honor, it's true that we are giving the benefit of the doubt to the Prims in this instance, but whether or not Mr. Prim was swaying, that's something that other people observed. That's not something that Mr. Prim could testify to. Whether his eyes were bloodshot, unless he was looking in a mirror, I'm not sure how he would be able to testify what his eyes looked like. So the officer's testimony about how he appeared to them, certainly, and it was consistent for all four officers, that's not really in dispute. I mean, he says, look at the videos. The videos have nothing to do with what happened at the concert as they were making their way to the first aid office. There is no video of what happened, the interactions with Mr. Harshaw. None of that was caught on camera.
Go ahead.
Oh, go ahead.
The trial judge here often is abbreviated in his rulings, to put it mildly. In this instance, he did write, some pages, but I do note he tended to group them, the Prims, and so he says what he does about Janet, but he doesn't really say much about Eric Prim along the lines of what Judge Wilson, was just kind of asking. So we've got these two people, and we're trying to separate out, the reasonableness, vel non, of the participants as respects two people. So counsel opposite, started with the 88 claim, and so most of this obviously refers to Janet. But as to Eric, it's a little harder to parse out. Yes, they both were drinking, that kind of thing, but whether the officers, in other words, reacting to Eric, it's kind of reasonable in the same dimension along the lines of what he has, the slurring, you said that. But anyway, I'm just saying, just quick reread, and I didn't remember saying, there's just not much in there about Eric to say, well, da-da-da-da-da. I mean, so given the summary judgment and so forth, I mean, what should we conclude, or said differently, as Judge Wilson was saying? I mean, construing the facts and the like, most favorable to the non-movement, Eric, help me understand that path. I think we got Janet's kind of clued in at least where the contest, so but just help a little bit as relates to the claim against your client.
So, Your Honor, actually, there are two groups of claims, if you will. We've got the federal claims, the ADA and Rehabilitation Act claims, and we've got the state law claims under Texas law. Those are the assault, false imprisonment, and negligence claim. And what the court said, actually, in a very abbreviated opinion with respect to my clients, is simply that there were no fact issues. That, and it's true, when you look at the record here, there's no case law cited, there are no facts that support any of the claims. They fail as a matter of law. So if I could briefly just go through those claims to explain why it doesn't really matter, even no disrespect intended, but it doesn't really matter whether Mr. Prim was in fact intoxicated that evening or not. The claims that they're asserting have to do with Mr. Harshaw escorting them together to the first aid office. That's really where it starts and ends for my clients. So with respect to the federal claims, statutory claims are clearly resolved in favor of the defendants as a matter of law because, number one, none of the pavilion defendants are a public entity. They're not state or local governments, my clients. So Title II of the ADA and the Rehabilitation Act simply do not apply. There's no viable claim against them under those laws. And the ADA Title III claim also fails here because if there are three elements required, and neither Mr. or Mrs. Prim has satisfied them. First, Mr. Prim doesn't have a disability, so he's not entitled to allege some sort of disability discrimination. And neither were denied full or equal enjoyment because of a disability. They were actually treated the same. Until just now, I wasn't sure really what the Prims wanted, and it seems like the injunctive relief that they're asking for is that you should force people to give you a ride home from a public event. I mean, that was not clear to me that that was what they were seeking here. It seemed
Well,
from their
that's why I like
briefs.
to routinely ask. Many a person stands at that podium and never make clear what in the world they want when they're here. You'd be surprised over time what people say or don't say. You know, they tell us everything else, but, you know, what do you want us to do? So it's illuminating, I shall just put it that way. But I was going to ask you about the injunction, but keep going.
Well, Your Honor, it seems like maybe they were complaining that we did not issue field sobriety tests. Apparently,
Your client, Mr. Harshaw, coach, security guard, is the one who escorts them to the first aid office, right?
Correct.
So what else does he do?
So that's really it. He called for a medic. Somebody came with a wheelchair who helped Ms. Prim, guided her into the wheelchair. Her testimony was, frankly, I was very happy to see the wheelchair because without Eric to hold on to, I would have been on the ground. Well, they told me they forced me into a wheelchair, so you have this notion of was she forced or was she guided? She said, just verbally, in response to the question, just verbally forced you by telling you get in the wheelchair? And she said, no, I think they moved me and put me in the wheelchair. Do you think they grabbed you? I'm not pushed you in the wheelchair. Did they help guide you in the chair? I'm not saying I objected to the wheelchair.
Just within there, but I'm just trying to get point A to point Z of your client's contact. So I got it, gets him to the first aid office, the wheelchair. So then what else does he do, and then when does he exit and so forth?
He leaves. He takes them to the first aid office. If you believe Mr. Prim, he said something like, these people should be arrested.
Counsel, let me,
Yeah, no, go ahead.
one thing on this point to build on this for Mr. Prim. What about the assault claim? Because there is an allegation that, I guess it was your client who grabbed him on the arm. He replies, you're hurting me, or that hurts, or something like that. And there seems to be, so there's evidence in the record about that, but tell me about the assault claim and how we survive summary judgment between the he said, she said there.
So if,
Or he said, I guess.
again, if you take Mr. Prim's testimony as true, that he really was grabbed by the arm and led to the first aid office, escorting somebody to a first aid office under the few cases that we found, and there are very few cases that deal with assault claims under Texas law of this nature to begin with, but it just cannot be sustained as a matter of law, because the test would be, would Mr. Harshaw have reasonably known that it was offensive or provocative to guide him to the first aid office?
But grabbing his arm for what, a minute or something like that?
It was about a minute, according to the testimony of the Prims. It was about a minute. There was a whole lot that Mr. Prim couldn't remember to recall in specific detail. But even according to Mr. Prim, Mr. Harshaw released him immediately when he said, you're hurting me. There were no marks on his arm.
But is that enough under Texas law? Because you don't have to have damages for assault, correct?
So we believe, Your Honor, that there's very little case law that we found that was helpful on this, but there's a Northern District of Texas case card, which we cited in our brief on page 21, in which the court said it's the rare situation where that action, placing a hand on somebody's arm, could be reasonably perceived as offensive or provocative. The cases where you find somebody grabbing somebody that might be assault are generally overtly sexual. Obviously, that doesn't apply here. The case that's also very instructive, although obviously not binding authority on this court, is from the Seventh Circuit. We cited it at page 22 of our brief, and there the court held that a battery claim that was very much like the assault claim here under Illinois law was properly dismissed on summary judgment. There, a flight attendant thought that the plaintiff was potentially a bomb threat, so grabbed the woman's
Is
arm.
Illinois law the same as Texas law in terms of the particulars as far as damages or the proof that's required?
It looks very remarkably similar to me, Your Honor. Obviously, it's different states' law, but it's essentially the same test. And the question is whether a reasonable person would have known that this was offensive or provocative. And we believe very firmly, Your Honor, that the summary judgment should be sustained on the assault claim as well, because the Prims simply don't have any evidence that Mr. Harshaw should have known that he was doing anything offensive by guiding Mr. Prim to the to the first aid office.
All right.
And there weren't any damages, too. That's very clear from the record that there was no bruising. This was not an instance where he suffered any sort of damages. So I know that I'm out of time here. But, Your Honors, if I might...
I'll give you one declarative sentence, no semicolons, no brackets.
Oh, that's really hard.
Go ahead. One declarative sentence, no semicolons, no brackets. Go for it.
Well, Your Honor, just we believe very firmly that on all the claims, there was no evidence to support each of the elements required, and therefore the judge properly ruled below on the summary judgment, and we respectfully urge you to affirm that judgment.
You had one comment, but you did good.
Thank you, Your Honor.
All right. Thank you, counsel. Appreciate your help. All right. On behalf of Deputy Stein, first half, Mr. Anderson.
May it please the court. My name is Adam Anderson. I'm here along with co-counsel Daniel Plake. We're representing the appellees Stein, Terrell, Webb, and Montgomery County. I plan to focus the court's attention on the Fourth Amendment constitutional claim. Mr. Plake will address the ADA as well as the expansion of the
Tell
manufacturer's
me
dispute
this,
rule.
why were these people held all night or as long as they were, given whatever the purported reasons were? I mean, why were they in jail for all this long period of time for, whatever? I mean,
Your Honor,
facially, that seems unreasonable to me. I'm not talking about unreasonables in the Fourth Amendment sense, but even taking the facts as they are, I mean, they don't look like axe murderers. They don't carry machetes. I mean, they don't have masks on their face and not this kind of mask, hoods on their head. But I mean, so they're coming from the concert. So, all this is done, but yet they're taken over here to the jail and then they're over here forever and this and that. I mean, facially, that seems unreasonable to me. Again, not talking about Fourth Amendment, but just facially, I'm like, what's going on here?
yes, Your Honor. So once they were actually taken to the jail, the reason, and I believe there's probably it's a perspective on how long you're actually in jail to whether or not you're there for a long time or not. But of the roughly 8 hours that they were there, that
8 hours? That's a work day. What do you mean as a perspective? 8 hours is a work day to be in a jail when you're not an axe murderer?
Your Honor, being they were...
You didn't prepare for that question, did you? Your script doesn't help you.
Yes, sir. The ADA actually reviewed it, and he believed that they should have been released when he did release them and drop the charges because he viewed it as a safety concern.
ADA, where was he? In bed?
I believe he was there that night. I believe they're on call.
So the ADA was present, and they kept these people 8 hours to figure out
And then they dismissed the charges,
that
Your Honor.
they ran the NCIS, they wasn't on the wanted list, there were no warrants looking for them, the prints cleared, they didn't have expired tags, none of that. They've got 2 people that have been to the concert that sells them alcohol to make money. They don't make money off the tickets, they make money off the alcohol. They go to dinner, they're in the concert, which sells alcohol because they don't make money off the tickets, they make it off it. So they wobbly bobbly, okay? So they get the wheelchair, et cetera, figure out no issues, get them a cab, go home, whatever. It's just the 8 hours that bothers me. Just seems not malicious motives, but just...
Once again, Your Honor, based on the...
Make your argument, I'm sorry.
Thank you, Your Honor. Mr. Prim exhibited multiple signs of intoxication that are uncontroverted.
Oh, you gonna steer away from my 8 hours. I got you. You gonna pivot to something else. Go ahead, Counsel. I don't blame you. I do the same thing.
Mr. Prim exhibited the smell of alcohol in his breath. He admitted to drinking multiple alcoholic beverages. His gait was unsteady. He had bloodshot eyes. He was given a horizontal gaze nystagmus test, attempted to give a horizontal gaze nystagmus test multiple times, which
took 8 hours.
No, Your Honor, that did not take 8 hours. He did fail that test because he was unable to keep his head still while they were attempting to do the test. Officer Stein did detect a nystagmus at that time. Mr. Prim was slurring his words and he was unable to stand straight and steady. These were what were relied upon at the time for the officers to determine he was showing signs of intoxication. and that's what got him to place him under arrest for public intoxication. As was already stated, Ms. Prim was also exhibiting multiple signs of intoxication, and the issue that the officers had, whenever they requested the Prims to provide them with contact information for somebody to come pick them up because they couldn't release them, because as Judge Wilson already mentioned, they were going to have to cross multiple lanes of traffic, which were heavily being trafficked after the concert. They were unable to provide any phone numbers.
Could have just said the hell of 8 hours because there was nobody to come get them and so forth. I mean, I threw you a beach ball. You know, you could have said, you know, it took 8 hours to do it. Anyway, I'm just...
And, Your Honor, once again, the officers, Stein, Terrell, and Webb, did not hold the defendants for 8 hours. They got them to the jail, and they let the process take its way.
Right. So correct me, how long were they there? Not trying to be facetious, it did seem faithfully to me a long time, you know, given all things. So just tell me, does the record really say, it's not dispositive, but just what was the period of time?
And, Your Honor, I don't have the actual
I mean, just
answer.
roughly, just a couple hours?
I believe, once again, I believe that it was approximately 8 hours, but I would like to get back with the court with the correct on that.
Okay.
What prompted their release?
Once again, it was based on the ADA's determination that this was really a safety concern, and after sitting in jail till they were no longer a danger to themselves to be released, he believed that they've served their...
Put them in a drunk tank for 8 hours to sober up so that they was then safe to put back on the street? Is that what the argument is?
That's in the record, Your Honor, that is what the ADA released for.
To sober up?
Sober up. And so they weren't, once again, they were not a danger to themselves, and he viewed it as a safety issue.
So the sheriff is shielded by the good old ADA who gives the good legal advice. Is that the deal? And is the ADA, is the assistant district attorney a defendant in the case?
He is not, Your Honor.
Press on, counsel.
Thank you, Your Honor. Once again, after repeated attempts to get contact information, as well as to even elicit their home address for there to even been a facilitation of them getting home, the Prims refused to give their home address to the officers. Based on all of the signs of intoxication presented by both of the Prims, it was determined that they were a danger to themselves and others, and they were placed into custody for their safety. The Prims have failed.
Madam Clerk, give Mr. Anderson 2 minutes. I threw him off his argument considerably, and I apologize. Well, not really, but
No apology necessary, Your Honor.
give him 2 minutes so you can make your. I did throw you off for a long time.
The Prims have failed to contest the facts pertaining to the signs of intoxication they were exhibiting at the time of their arrest. Rather, they've chosen to focus on an incorrect standard of whether or not they were actually intoxicated. This argument is irrelevant to undermine the qualified immunity defense raised by the officers, as the question is not whether or not they were intoxicated, but whether or not a reasonable officer could have determined that they believed that they were. Based on all of the signs of intoxication they were exhibiting that are uncontroverted, Mr. Prim did not controvert that he was smelled of alcohol, that he failed the horizontal gaze nystagmus test, that he admitted to having alcoholic drinks. He did not controvert any of that. He later filed a declaration. A year later, he filed a declaration that had to do with his state in front of Mr. Harshaw. It had nothing to do with his symptoms that he was displaying in front of the officers. So there is no controverting evidence to any of the signs of intoxication that Mr. Prim was exhibiting when he was placed under arrest. And based on those signs, he was placed under arrest for public intoxication and being a danger to himself or others. So once again, Your Honor, we'd ask this court to affirm the judgment of the district court. Thank you.
All right. Thank you, Mr. Anderson. Appreciate your responses to the questions and argument. Mr. Plake? How you pronounce it? Plake? Plake?
Plake.
Plake.
Like Blake
okay.
with a P.
All right. Thank you, sir.
May it please the court, my name is Daniel Plake. I am here with Mr. Anderson on behalf of the Montgomery County defendants. Under the current rule, the court or the district court could disregard testimony in affidavit form that's used to defeat a motion for summary judgment if it contradicts a prior deposition testimony and is unexplained for the contradiction. We would ask the court to expand that rule to the facts of this case. In this case, it was not the traditional deposition with a affidavit attached to the response to summary judgment. Rather, we had written discovery at first, and then that was contradicted in deposition in its entirety. And then in deposition, particularly in this case, we had two deponents, both Prims. Mrs. Prim first testified as to three basic categories: pre-dinner drinks, drinks at dinner, and drinks at the concert. Her testimony was unchanged by any physical evidence because she didn't have access to it. When we deposed Mr. Prim a couple weeks later, he gave the exact same story that Ms. Prim gave, or very similar, if not exactly the same. But then we started showing credit card statements and then credit card receipts. And each time the testimony changed to match the newly presented evidence. And then in response to the summary judgment, he actually filed a declaration. Both Prims filed a declaration, which is flawed for two reasons. First, their declarations do not address what the officers saw. They specifically address what they say Mr. Harshaw saw, which was...
To the chase, what are you asking us to do? To strike something? Is that what you're...
Judge, under the current rule, well, we're asking you to focus on the sworn nature of the testimony and whether or not, and this is an alternative theory. We do not believe you have to get to this because we do not believe the exact number of drinks is a fact issue in this case, not a material fact issue that would overturn the summary judgment. But if you do get to that and find that is a material fact issue, we ask you to expand that rule to allow the district court to disregard their testimony in this case as to their number of drinks, because their testimony is so obviously false as presented in, it's just like the manufacturer dispute rule, the sham affidavit rule. They're changing their testimony to meet the newly discovered evidence in an attempt to survive their summary judgment.
No, that's fine. I just wanted to, know where you were headed.
Okay, and if specifically on the number of drinks in the initial, the pre-dinner drink session of the night, Mr. and Mrs. Prim both testified that they specifically remembered a $100 credit card charge. They had produced a credit card statement, not the receipt, and they remembered that was their one drink each, and then their son and daughter-in-law showed up and they had a drink, and they also remember the son and daughter-in-law eating dinner, and they paid for dinner, and of course it's Bank of Dad, and son didn't pay anything, the dad paid for all of it, and that explained the $100 charge. But when we showed Mr. Prim the actual receipt and showed that it actually was drinks, oh yeah, now I remember it's actually 2 drinks each instead of 1 drink each. So we already have them increasing the number of their drinks. And then when you get to the dinner receipt, it's kind of the same thing. We had 2 glasses of wine each, but when we showed the actual receipt, it was 22 drinks for a party of 5. Well, maybe we had more than that, maybe it was 3, I don't know. And then when we get to the actual drinks at the concert, the initial discovery, which was, I believe, an interrogatory, it said we had 1 bottle of wine, we paid with cash, and just us 2 drank it. But in deposition, every part of that interrogatory is wrong. They had 2 bottles of wine, they paid with credit, and they shared it with 5 people. So they're constantly changing testimony. Just shows that their credibility, it's not even credibility, that it is a purely manufactured dispute. They're trying to raise the number of
I'm
drinks.
struggling to follow your argument, frankly, because it doesn't seem like to me that you want to go here, because say you've got these discrepancies in the Prim's testimony, their declaration, their deposition testimony. I've been there before where you put something in front of a witness and all of a sudden they're confronted with reality, and then you put something else in front of a witness and a new reality they're confronted. So I get that. But counsel opposite still has this expert who testified, well, this number of drinks wouldn't have led you to be intoxicated. I mean, so it seems to me that if you want to fight on the ground of how many drinks and whether they were intoxicated, you would lose on summary judgment, wouldn't you?
No, and that's our point, is that even though you're correct, we do not believe that the specific number of drinks creates a fact issue. So it is an alternative theory if the court goes there. The district court did not address it. It was not responded to in a brief. So we don't think that you have to get there. But if you do find that their testimony as to the number of drinks or Mr. Platt's report as to their level of intoxication does create a fact issue, then we believe the district court should be able to strike the testimony as to the number of drinks from the Prims as it's a defense of this. Because it goes back to...
Why would it be struck, though?
It would be struck because it's obviously false, and they've made it up. They're trying to make up the number of drinks to show we were not...
We up here don't typically, make those kind of assessments.
No,
I'm just trying to follow what you're urging us to do. I mean, I get it. You want us to perceive, the inconsistency, but I mean, we as the Fifth Circuit wouldn't typically be opining, to strike something that's in the summary judgment record that we find. You follow me? I mean, it's not. So I mean, to figure out what, I get it, it's your alternative theory, but to say we should, not credit it, et cetera, but that's not what we're doing. We got a Rule 56, construing the evidence in the light most favorable to the non-movements, which is their side. As Judge Wilson says, they've got an expert. You're, helpfully putting what's there, but it's just what's troubling me is when you're saying if we go there, we should strike affidavits and something, and I'm just not following why we as a Fifth Circuit would be empowered to do it or even do it.
Well, I think In this case, if you got there, you could do it, but what I'm really asking is if it was to be sent back to the court, like the rule would be expanded from the current, which is oral testimony changed by written testimony.
You can't create a fact issue for summary judgment by contradicting your own prior sworn testimony.
Correct.
Okay.
But in this case, the testimony was inside the same deposition, and although it does help us that they kept upping the number of drinks they had, what they're trying to say is, well, we only had this many drinks, and that's what Mr. Platt is relying on. I mean, that's one of the flaws of his report is based on essentially evidence that they know is false at this point. And it also goes strictly to he's going to almost a DWI standard and a criminal defense theory rather than a probable cause theory under the officer's point of view.
Okay.
Thank you.
All right, thank you. That's helpful. All right, appreciate it. All right, Mr. Kallinen, you have rebuttal.
Opposing counsel calls the security office a first aid office to kind of continue this theme that we're trying to be helpful. If you look at the video, all they do there is the Prims sit there until they come and they get arrested. There's no doctor there, there's no nurse there, there's nothing. And this concept that there was a lot of time between the time they're arrested and they show up in that video, it's like a minute or two, because that's exactly where they're going. They're going to the security office. That's when Mr. Prim was grabbed painfully. And under the case law, that is enough. Offensive touching is enough. And there was pain, and under the law, that is all that is required. So when you look at the video, there's a lot of...
A common law assault is a touching unconsidered to. That's the first step from a constitutional violation of some of the predicate of federal jurisdiction. So you have to be talking about something that rises to beyond a simple touching.
Fisher versus Carousel, as quoted by, cited by the...
You're talking about unreasonable force and affecting a...
with Mr. Harshaw, it's assault. With any police, it would be... We're not suing the police for excessive force.
Mr. Harshaw, you say...
Right, he's a private individual. He's a security guard.
You say it was assault with Mr. Harshaw because they were...
Yes, because all that's necessary under Fisher versus Carousel Motors, as pointed out in plaintiff's 32 of their principal brief, Supreme Court of Texas, 4424 Southwest 2nd.
What is they holding that that's an assault, right?
Oh, well, they held that...
An assault.
Right, the defendant made contact with the place...
And that's an assault.
Right, exactly.
Okay. Now, tell me what that gets you in an allegation that a constitutional deprivation or some basis of federal court.
I'm talking right now about Harshaw, the individual, because we also brought under pendent jurisdiction, we also brought in an assault claim against Harshaw and under respondeat superior to Cynthia Woods Mitchell Pavilion and Live Nation. So that goes to that. We're not claiming that the officers used...
What does the district court do with regard to the state law claim? You're saying these...
It was granted summary judgment.
Supplemental jurisdiction.
Yeah, it was under pendent jurisdiction, right.
But that's called supplemental jurisdiction.
Yeah. Supplemental jurisdiction.
About it, but that is the rule.
Yeah. So, Your Honor, if you look at the video, I think that's the clearest, and there's a clear contradiction in the video with what the other side is claiming as to stumbling, slurring, and then also there's the video in the backseat of the squad car. Now, I've heard the opposing counsel claim at some point, basically, and I paraphrase, that, they sobered up in the 50 seconds or the 30 seconds from when they were stopped until they got to the security office, which, once again, is not a first aid office. There's no nurse there, no doctor there. They were given no first aid. So at the security office, furthermore, it was testified that all three of the officers sued, and this is an oddity, are actually employees of the Cynthia Woods Mitchell Pavilion who show up in full uniform and so forth, which in my civil rights practice, I very, very seldom see that they've actually got them on a payroll, they take out taxes and everything. from them. So all three of the sued officers were actually employees of the Cynthia Woods Mitchell Pavilion, as testified and put into the.
Well, but counsel, that's not remarkable. I think there are concert venues all the time that hire either off-duty deputies and sometimes deputies on duty who are there in uniform and that sort of thing. You're saying this is a different arrangement?
Contract. They're actual employees.
These
They
are
actually
actual
take taxes out and they get, they're actual employees.
Are they, so they're also employees of the Montgomery
Yes, that's what they
County?
testified to. The employees asked them, did you take, they take taxes out and you get a paycheck? They said,
No,
yeah.
but I'm asking you, they're also employees of Montgomery County, in other words?
Yes.
Okay.
They're employees of both.
Under what capacity were they operating that night?
It sounds like a mixed capacity because they came on the word, they were there at the Cynthia Woods, and then they were there on the word. They came into the security office to arrest the plaintiffs on the, I say command or suggestion of Mr. Harshaw, who was in some sort of a managerial position in his security, being a security guard. So it's almost as if, because he was in a managerial position with, and I say manager like a low manager, a security, that they listened to him and say, okay, so the Cynthia Woods Mitchell Pavilion guy says, arrest him, so that's what we do, because that's who our employer is Cynthia Woods Mitchell Pavilion. Although at the same time, they're on the county's payroll, and this kind of mixed question, it's really not a good thing to be on two different payrolls. And they all
Alan, you have a red light, you want to make a conclusion?
oh, let's see, yes.
Got one more sticky note over there?
I just wanted to say, Your Honor, that Ms. Prim would like to be free to go to a concert and not be arrested and put in jail.
All right. Thank you, sir. Appreciate your briefing and your argument and your responses to the court's questions. Counsel at the table, appreciate your briefing and help to the court. That concludes the argument in this case. It'll be submitted. We'll get it sorted out and decided. Thank you. All right, we call the second case, 20-50827.